be Samantha Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. If you were going to do probable cause, you have the right to remain silent.
Right out the gate, things get intense. Assault charges involving family members are serious, especially when minors are involved. But the law doesn't play favorites. Notice how the judge is already laying down the Miranda rights. That's not just protocol. It's a signal this case could escalate fast.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford, one will be appointed to you, man.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant.
Whoa, minor injury, prior incidents, and now video evidence. That's a triple threat in the courtroom. When a judge hears about a pattern of behavior, it changes everything. What do you think? Should past history weigh heavily in new charges? Let us know below.
And the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
So we have prior violence, any prior charges?
There's no prior charge,
No
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
Child means 14 years or younger. Ma'am, I'm going to find that there's probable cause to go forward. Ma'am, you have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help.
Yes, Judge.
You know, this is a 15-year-old child. We have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
And now we're entering CPS territory. Judges don't just look at the incident, they zoom out to assess overall safety. The moment CPS gets involved, it adds layers of bureaucracy and emotion. This could impact custody, visitation, and even parental rights down the line.
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a Walker?
Yes.
Which Walker?
Walker. So, what my plan was, and I already spoke to my people about this, is we were going to check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other to be granted based off of the allegations of the history of
What about now?
violence?
Is there something that we can do now as far as finding out where the child is?
Well,
You
we're
know?
going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
I'd like to, because I think it's serious. And if we have a history of violence, I don't want that to happen anymore. I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. If I find that there's a history of violence with the child, I'm going to order you not to have contact with this child.
I understand.
As it stands now, I'm entering in called a magistrate's order for emergency protection that identifies EJ as a protected individual. You
I have to take her to appointments and stuff like that.
Please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order.
Here's where the legal system flexes its protective muscle. The emergency protective order isn't just paperwork, it's a legally binding shield. Violate it, and things go from misdemeanor to felony real quick. And yes, even texting the victim could count as a violation.
They're going to file additional charges against you. I'm entering in an order for protection against this person. Commit an act in furtherance of an offense under section 42.072 of the Technical Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. Do you understand? I'm entering this order now. we will try to figure out about how we go from here. But my only concern is the protection of this child. To me, nothing else matters. I know that you're telling me one thing, but the evidence show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?
No, Judge, we did it. So, Judge, I met the defendant with defense in the room.
Oh, okay.
So I'll let defense.
Your Honor, I showed him some video of the alleged assault, I believe. Of course, I haven't gone through the state's discovery, but this, in my opinion, is a child out of control. She's on juvenile probation in Tarrant County, according to her mother. The complaint says that she caused bodily injury by grabbing her. The complaining witness has a statue. She's threatening to get a knife. She's bigger and stronger than my client.
Did you catch that? The defense just flipped the script, accusing the child of being violent and claiming mom's been trying to get her help. This is where courtroom drama meets real-world tragedy. The emotional stakes are sky high, but legally, it's still about evidence and precedent.
My client's called the police numerous times.
This is why we appoint.
And so
there's
I
always
think-
two sides, right?
I think this is almost enabling the child. When the police saw all this, but they're so sick of going out there, they're like, we're somewhere.
But I don't understand.
Restriction to not granting a MOAP at all. And to just.
No more.
I wouldn't.
Okay, I mean, if that's what you think, I'll go with what you think.
Based off what they're telling me, Judge, and I did corroborate some of the information as well. We're just going to subpoena the CPS records to take a look.
Come up, Ms. Walker, come up. So I guess the $25 million question is,
My power to love her, do everything to help her get some type of mental help. I've had her admitted to several programs. I've even contacted CPS myself personally, had them come out to the house. She got up and walked out on us. I've tried therapy. I've tried medication.
hell hath no fury as a scorn. This is a very interesting issue. I've really never run across something like this before, where they really have just out at the outset said, hey man, if you blow, which is essentially what's happening here, right?
Yes, Judge.
Do you have any case law that says that it's okay to say that?
We have case law that says that the case that he used is overturned.
Judge, and we also have Sandoval v. State, which is from May of 2000 from the Court of Appeals of Texas, and it does.
You're saying May of 2000. When was this?
I think that one's pretty old.
Oh, this is 95. Okay.
And it's from
What case do you have?
Sandoval.
Can I see a copy?
Yeah, here, we can keep
Oh,
those.
I think
You want-
I actually, Judge, may I hand you?
No. They're talking.
So Sandoval is almost the same thing as our, I forgot the last name, but
Same thing.
I already know your position.
So-
I'm trying to get theirs.
it states the same thing. And the officer in this case with the facts stated, if you blow under, you can go home. And the Court of Appeals held that the court did not abuse their discretion by letting in the breath test, that it was statutorily, it was outside the statute requirements of the DIC reading, but that it didn't
A court
Directly.
found that was not.
abuse of discretion from the trial court. Yes, Judge, for Sandoval.
Okay, so but they let it in.
Yes, Judge.
Right. But is there something that says if it's let out, it's an abuse of discretion?
That, no,
Is it?
Yes.
Okay. So
Yeah.
have you seen the cases that they cited? Okay.
I know these cases. May I point something out to you?
Sure.
Was that Navarro that you just read?
I think I'm looking at your Finian. I don't think it's on point. This is just whether this guy was more afraid about getting stuck by a needle, and that's why he wanted to blow as opposed to.
100%.
Whereas this one's more on point, where I think it go either way.
It's 100% on point. And then what I wanted to point out to you.
Now we're knee-deep in breathalyzer arguments. The defense claims improper language by the officer influenced consent. Classic coercion by confusion. The judge's ruling here could set a tone for future DUI cases in this court. Think it should be thrown out.